Um, I want you to start by picturing an image in your mind, and it's incredibly cinematic. Picture the United States Supreme Court building.
Oh, right.
You know the exact one I'm talking about, right?
Yeah.
Those massive, pristine, white marble columns, the grand sweeping steps.
Yeah, the imposing pediment at the top that reads equal justice under law.
Exactly. It is designed to be the ultimate architectural embodiment of fairness. It just projects this total absolute neutrality.
Right. I mean, it's a structure built entirely to communicate authority and this unwavering objectivity. When you stand in front of it, you're basically supposed to feel that the law is a protective shield.
But now, I want you to alter that image in your head just a little bit. Picture something hanging right off the side of one of those pristine marble columns.
Okay.
It's an old, rusted, heavy metal sign swaying on a chain. And the painted letters on the sign read, "Colored Waiting Room."
Wow. That is just a completely jarring visual contradiction.
It really is.
You're taking the ultimate symbol of the law's promise and forcibly attaching the ultimate symbol of the law's historical failure.
It makes you stop dead in your tracks. And that specific striking image is actually the cover art of the primary source we're exploring today.
It's quite a cover.
Yeah, it's a book by David Arnold Gray called Jim Crow in Civil Rights Law, which you can find on Amazon. But we aren't just doing a standard book review today, are we?
No, definitely not. We have a whole stack of sources.
Right, we have the narrated framework of Gray's book, breaking down his theories act by act. But here is the hook. We also have an actual real-time federal lawsuit.
Which is fascinating.
Case number 25, CV-256-DAY DPG, filed on February 2, 2026, by David Gray himself against Miami-Dade County.
And that detail turns this from an academic exercise into like a high-stakes real-world laboratory. We aren't just dealing with abstract legal theory about modern discrimination anymore.
No, we are watching the author of a legal framework deploy his own survival tactics in the federal court system.
Exactly. He is literally testing his own thesis under fire.
And that really sets the mission for this deep dive.
Yeah.
Because if you are listening to this right now, you need to understand this is not a history lesson.
Not at all.
This is a survival guide for the modern professional. Gray argues that we are living in what he calls the accountability era.
Right.
And the goal today is to teach you how to defend yourself in this era by mastering 3 very specific skills. Number 1, seeing the invisible legally.
Crucial skill.
Number 2, recording the soundless structurally. And number 3, holding the untouchable accountable with precision.
And those skills are so necessary because of this central, brilliant paradox that Gray's work forces us to confront.
Okay, unpack that paradox for me.
Well, he asks this question when the civil rights movement succeeded in taking down those visible signs, like that rusted one on the cover of his book, where did the discrimination actually go?
Right, because it didn't just vanish.
Exactly. Because if you look at the data, if you look at the outcomes across public institutions and corporate environments, massive systemic disparities still exist.
That's the thing. I feel like we are all taught that the Civil Rights Act was, the finish line.
Yeah, a lot of people think that.
The law changed, the signs came down, the explicit rules of exclusion were destroyed. We just assumed that meant the door was finally kicked open. But Gray is arguing that power doesn't just surrender because a law was passed, does it?
Power never surrenders. It adapts. I mean, it relocates.
Relocates how?
Think about the historical record. Under the original Jim Crow system, discrimination was unmistakable because it operated through visible architecture. Segregated spaces, explicit signage, clearly defined rules.
It told you exactly who could enter a space and who couldn't.
Right, it was totally undeniable. But when the law successfully targeted those visible, explicit mechanisms, the underlying system of power had to learn to function without naming race or gender.
So it had to go underground.
Yes. It had to embed itself within neutral procedures that appear perfectly fair on their surface.
Okay, let me try an analogy here, because I want to make sure I'm visualizing this relocation of power correctly. Tell me if this tracks.
Let's hear it.
It's like you're trying to get into a highly exclusive nightclub. Historically, the bouncer just looked at you, checked your demographic, and said, nope, you can't come in.
That's the visible barrier, yeah.
Right. Then the law comes along and says, you can't do that anymore. You have to let them in. So you get past the tough bouncer.
The door is technically open.
But once you are inside the club, the bartender completely ignored you. The DJ refuses to play any of your requests. The security guards are just following you around all night.
Oh, that's good.
And the club manager is standing in the corner with a clipboard, logging every single time you look annoyed or frustrated. They're basically setting you up so they can kick you out, not for who you are, but for having bad vibes.
That analogy captures the exact mechanism Gray calls the conditions of participation.
Conditions of participation. Okay.
To build on your nightclub scenario, the bouncer is no longer the threat. The threat is the environment inside.
Because you're already in the building.
Exactly. Under the original system, you were stopped at the door. In the modern system, you are granted entry. But you remain subject to unregulated subjective authority once you are inside.
So the trap isn't the lock on the front door anymore.
No, the trap is the atmosphere you are forced to navigate once you cross the threshold.
And what makes that so incredibly insidious is the optics of it all. I mean, to the outside world, to anyone walking past that nightclub on the street, they see you walk in and they think, hey, equality achieved. They got in the club.
And that's what Gray calls the illusion of the open door.
The illusion of the open door. Wow.
If we connect this to the listener's everyday life, think about your own workplace or the institutions you interact with. We constantly trust the appearance of a fair process.
Like we see the corporate diversity statements on the website.
Right. We see the blind hiring practices, and we automatically assume the structure underneath is sound.
We trust the appearance without questioning the underlying mechanics of how outcomes are actually produced for the people operating inside the building. So, if exclusion is now happening through these conditions of participation, how exactly is that trap set? I mean, how does a modern institution push someone out without looking like they're pushing someone out?
That leads directly to what the source text calls Gray's most critical discovery.
Which is?
This concept of managed failure.
Managed failure. That sounds chilling.
It really is.
Yeah.
If you look at Acts 4 and 5 of Gray's framework, he defines managed failure as a system where access is no longer denied, but success is systematically undermined.
So you are allowed to enter the institution, but what happens?
You do so under conditions that make favorable outcomes increasingly difficult, if not entirely impossible to achieve.
Okay, I have to play devil's advocate here for a second.
Sure, go ahead.
Isn't documenting an employee's performance, checking their tone, monitoring their communication style, isn't that just standard good management?
It's a fair question.
I mean, managers have to manage, right? If I start slacking off or rolling my eyes in meetings, my boss is going to write that down. How do you prove that a manager is doing this maliciously, like engineering a failure, rather than just doing their job and documenting someone who isn't a good fit?
That is the essential friction point of modern employment law. And it is exactly why Gray focuses so heavily on what he calls the preparatory phase.
The preparatory phase.
Yes, this is the invisible period that exists before any formal HR disciplinary action actually occurs.
Before HR is even involved.
Exactly. This phase determines the final outcome long before the outcome is formalized. And to answer your question about distinguishing this from good management, you have to examine the feedback loop that gets created.
Walk me through that feedback loop. How does it actually start?
It almost always begins really subtly, with a highly subjective observation. Like you said, it could be a comment on an employee's tone, their communication style, or their perceived attitude.
Okay, so a vibe check, basically.
Right. Now, you're right. On its own, a manager making a subjective observation isn't illegal. But the trap is what happens next. That single subjective observation is used as the justification to place the targeted employee under heightened scrutiny.
Ah. So the manager decides you have a bad attitude, so they start watching you closer than everybody else.
Yes. And what happens when a human being is watched closer than anyone else in the room?
They get nervous. They mess up.
Increased scrutiny inevitably produces more observations. Every minor misstep, every slightly delayed email, every sigh in a meeting is noticed and logged.
Oh, wow. So they just keep finding things because they're looking so hard.
Exactly. Those new observations are then documented and compiled. Over time, this creates a vicious self-sustaining cycle.
Because the documentation reinforces the manager's initial negative perception.
Yes, and that negative perception justifies even more intense documentation. It's a self-fulfilling prophecy.
That is wild.
Meanwhile, a differently situated colleague could make the exact same mistakes, but because they aren't under that microscope, their errors are treated as, learning opportunities.
Wow. So by the time it actually gets to human resources, it's an avalanche.
It is a complete avalanche of paper. The environment engineered the failure, but the system blames the individual's performance.
That is terrifying. Because if I'm the employee in that situation, I'm probably trying harder and harder to prove myself right.
Which is the natural reaction.
But that just makes me more anxious, which leads to more mistakes, which gives them more data points to scrutinize. It's like a death spiral.
It is a death spiral.
But how does this survive legal scrutiny? I mean, we have courts, we have labor laws. How are these raw, highly subjective observations transformed into a weapon that actually holds up in front of a federal judge?
This is where we get into Act 6 of Gray's framework, the creation of the paper reality.
The paper reality.
This is the dark alchemy of modern discrimination. The raw, subjective, often biased observations collected during that preparatory phase are systematically refined.
Refined how?
They are stripped of all the context that made them uneven or unfair in the first place, and they are translated into highly professional, neutral HR language.
So it's basically money laundering, but for HR complaints.
Wow, that is a brilliant way to phrase it.
You take a dirty, biased observation, run it through the bureaucratic machine, and it comes out looking clean and objective.
It is institutional money laundering. Instead of manager writing, "I don't like how confident he is when he disagrees with me," which clearly shows bias and would be a huge red flag.
Right, HR would reject that.
Exactly. It is translated into, "The employee consistently struggles to align with leadership directives and exhibits resistant communication patterns."
Oh man, that sounds so clinical.
Yeah.
So impenetrable.
That's the entire point. The resulting file appears completely neutral and perfectly compliant with organizational standards.
So it's totally by the book.
Yes. And here is Gray's critical insight. This record is not designed to evaluate fairness. It is designed to demonstrate compliance.
The compliance trap.
Yes. By the time this meticulously crafted paper reality is reviewed by an internal HR department or an external regulatory body, it carries the absolute weight of inevitability.
Because the file is just so thick.
Right. The outcome, firing the employee, demoting them, appears justified, not because the process was genuinely fair, but because the paperwork is flawless.
But wait a second. We have the Civil Rights Act. We have Title VII.
We do.
Why doesn't traditional employment law stop this? If this is happening to someone, why can't they just sue under Title VII and say, "Judge, look at this rigged process"?
This brings us to Acts 7 and 8 of the framework, the legal blind spot. Gray exposes a massive structural limitation within statutes like Title VII.
Okay, what's the limitation?
Title VII and similar employment laws were primarily designed to evaluate final decisions.
Like the actual firing?
Yes. The hiring, the firing, the formal demotion, they were not designed to regulate the subtle conditions that slowly lead up to those decisions over months or years.
So Title VII only cares about the very end of the movie, not the 90 minutes of plot that got us there.
That's exactly it. The preparatory phase, that whole feedback loop of subjective scrutiny and disparate grace, operates almost entirely outside of Title VII's primary field of vision.
Wow. So it's legally invisible.
Basically, yes. By the time legal protections are actually triggered by a formal firing or a demotion, the paper reality has already been fully constructed and cemented.
And when it goes to court, judges just look at that narrative as if it were objective reality.
Because it just looks like a thick file of legitimate performance issues.
But shouldn't judges be able to see through that? I mean, they're judges.
You'd hope so, but
Yeah.
this disconnect is reinforced by deeply entrenched judicial doctrines. First, courts generally require evidence of explicit bias to rule under traditional statutes.
So they want a smoking gun.
Exactly. They are looking for clear, unmistakable expressions of discriminatory motive. A smoking gun email, a slur. But as we established, power has adapted. It doesn't use that language anymore.
Right, it uses resistant communication patterns.
Exactly. Second, there is the doctrine of judicial deference. Judges are explicitly instructed by precedent not to act as super personnel departments.
Wait, super personnel departments. What does that mean in plain English?
It means judges are told, your job is to interpret the law, not to micromanage how a business runs its office. They are not supposed to second-guess everyday management practices, performance reviews, or how assignments are handed out.
And I bet institutions know this.
Oh, they know exactly where the court's boundary line is, so they exploit it.
Yeah.
They frame systemic sabotage and engineered failure as routine personnel matters.
This is a labeling trick.
Basically.
Hmm.
Once an institution successfully slaps the label personnel matter onto a situation, the deeper structure of the abuse becomes legally invisible. The judge steps back, and the system is insulated from meaningful review.
I have to be honest, I'm feeling a profound sense of hopelessness right now on behalf of anyone listening who might be going through this.
It is a very daunting reality.
If the law is literally blind to this, if judges refuse to look behind the paper reality because they are terrified of being a super personnel department, how can anyone possibly survive this? Are we just completely at the mercy of the managers writing the files?
It paints a very dark picture, but this is exactly where the deep dive pivots to the solution. Gray's work doesn't just diagnose the disease, it prescribes a very specific cure.
Thank goodness. Okay, what is it?
And that brings us to Act 9, the constitutional shift.
Hold on. You're telling me I can use the Constitution against my middle manager? I thought the First Amendment was just for, like, journalists or protesters holding signs.
A lot of people think that.
How does a dispute over an office privilege become a constitutional crisis?
It's a massive paradigm shift. Gray provides a pathway forward specifically for public employees. So people working for government entities, municipalities, public schools, state agencies.
Okay, so this is for public sector workers.
Right. He argues that instead of relying on standard employment statutes like Title VII, which, as we discussed, only look at the final decision, public employees must look to the United States Constitution.
Why is the Constitution better here?
Because unlike employment statutes, constitutional protections regulate how power is exercised, not just the final decisions that result from it. The Constitution actually applies during that critical preparatory phase.
Break that down for me. How does the First Amendment apply to my boss giving me uneven scrutiny?
The First Amendment isn't just about freedom of the press. It includes the right to petition the government for a redress of grievances.
Okay.
If you work for the government and you report discrimination or a violation of policy, and your boss threatens you to shut you up, that is a First Amendment issue. They are using state power to chill your protected speech.
Oh, wow. Okay. What about the 14th Amendment?
The 14th Amendment gives us due process and equal protection. Due process protects against actions taken or privileges revoked without fair procedure and notice.
So they can't just change the rules on you overnight.
Right. If you have a long-standing customary privilege at work, the law can sometimes view that as a property interest. They can't just take it away on a whim without a process.
And equal protection.
Equal protection challenges selective enforcement. If a rule is only ever enforced against you and not your white colleagues, even if race is never explicitly mentioned, that is an equal protection issue.
I see.
These constitutional principles operate in the environment, right in the preparatory phase where the real harm is actually occurring.
So you aren't fighting them on whether you were a good employee or a bad employee. You were fighting them on whether they violated your constitutional rights and how they managed you.
Precisely.
That is a completely different battlefield.
Yeah.
But how do you actually execute that? I see Act 10 of the framework talks about lawful self-defense.
Yes, lawful self-defense.
What does that look like on a Tuesday afternoon when your boss is starting to lay the groundwork for your managed failure?
Lawful self-defense requires understanding what the system wants from you. The system wants an emotional reaction.
Because they want you to lash out.
Exactly. When you realize you're being subjected to uneven scrutiny, the natural human response is anger, frustration, or defensiveness. But if you react emotionally, you are giving the system exactly what it needs to finalize your paper reality.
Ah, I get it. Your emotional reaction creates a brand new, highly documentable issue.
Right. Insubordination, lack of professionalism, aggression.
He raised his voice in the meeting. She was visibly hostile when receiving feedback. They don't even need to talk about your actual work anymore. They just write down your reaction to their unfairness.
Exactly. Lawful self-defense rejects that trap entirely. Gray teaches that individuals must respond to these systems not with emotion, but with surgical precision.
Surgical precision, okay.
You replace the emotional reaction with disciplined documentation. You force the institution to explain its unwritten rules in writing.
So if I'm listening to this, and my boss suddenly takes away my work from home days while letting all my coworkers keep theirs, I shouldn't storm into their office and demand an explanation.
Definitely not.
What do I do instead? Give me the template.
You ask highly targeted, unemotional questions in writing. You send an email that says something like, I noticed my remote work days were revoked while others retained theirs. What specific standard applies here?
Okay, what else?
Who made this decision? When did this policy change? Where is this written in our departmental guidelines?
That is brilliant. You are forcing them to articulate the invisible structure.
You are recording the soundless. Because if it's a legitimate rule, they can easily point to the handbook.
Right.
But if it's managed failure based on subjective discretion, they won't be able to point to a written standard. By asking these questions, you expose the inconsistencies. You shift the focus entirely away from your performance and onto their process.
Think about that for a second. If you were listening to this, think about how empowering that is. Instead of desperately defending yourself against the vague accusation of poor communication, you are making the institution defend its adherence to its own rules.
It completely flips the script.
You are taking the spotlight off your back and shining it directly on the structural mechanics of their authority.
It is the ultimate way to see the invisible and record the soundless.
Okay, so we've thoroughly explored the theory of Gray's book. We understand managed failure, the paper reality, the blind spot of Title VII, and lawful self-defense.
We've covered a lot of ground.
But theory is one thing. A book is just paper. Does this actually work in practice? When the rubber meets the road against a massive institutional bureaucracy, does the constitutional shift hold up?
That is where the second half of our source material comes in. Because we aren't just reading Gray's theories today, we are reading his actual legal filings.
Oh, I love this part.
We get to see theory meet reality.
Let's set the scene for this legal battlefront. We are looking at a document filed on February 2, 2026 in the United States District Court for the Southern District of Florida.
Right, a federal court.
The document is the plaintiff's response in opposition to defendant's motion to dismiss. Let's introduce the players here. The plaintiff is David Arnold Gray, the author of the book we've been discussing.
Yes.
The filing describes him as a middle-aged black male and a senior-level employee at Miami-Dade County's Housing and Community Development Department, or HCD.
Okay.
On the other side, the defendants are Miami-Dade County itself, the director of HCD, Nathan Colgan, and the assistant director, Christina Salinas-Cotter.
So we have the author of the framework going up against the exact type of institutional structure he writes about. He's testing his survival guide in the jungle.
Exactly. Let's look at the trigger incident that started this whole thing. According to the factual allegations in the complaint, Gray was subjected to disparate treatment regarding a customary employment privilege.
Okay, so an unwritten but established perk or practice.
Right. This was a privilege that was established and routinely applied within the department. Specifically, Gray was denied this privilege while it was regularly conferred upon similarly situated senior-level employees.
And routinely granted to white male employees, according to the filing.
Yes, and it was denied to Gray without any justification and without due process.
This is a textbook example of the preparatory phase beginning. An unwritten, customary privilege is suddenly and unevenly revoked using subjective discretion.
Just out of nowhere.
Now, remember what we just discussed about lawful self-defense. The system expects an emotional reaction. It expects Gray to get angry, to storm into an office, to be insubordinate so they can start building that paper reality.
But Gray literally wrote the book on this, so he doesn't take the bait. Instead of reacting emotionally, he deploys lawful self-defense.
He engaged in protected activity.
Exactly. He submitted a written email petition directly to defendant Salinas-Cotter. And he didn't just complain, he was precise.
What did he do?
He expressly invoked Miami-Dade County's specific anti-discrimination and anti-retaliation policy, which is implementing order number 745. He put it in writing, asked for redress, and shifted the focus to process.
And how did the institution respond to that disciplined written petition? Did they address the substance of the policy violation?
Not at all. The response from Salinas-Cotter was to meet his petition with official threats of discipline.
Wow.
The filing says she responded in a manner reasonably likely to deter a reasonable employee from engaging in protected activity, invoking official authority to impede his redress.
If we look at this through the lens of Gray's framework, this is the institution attempting to forcibly construct the paper reality. Salinas-Cotter is trying to use the preparatory phase to chill his speech.
By threatening discipline for raising a policy concern.
Yes. She's attempting to reframe a civil rights complaint into a narrative of employee insubordination.
He's not a whistleblower, he's just a problem employee who can't take direction. So she threatens him. Most people would fold right there. What does a guy who literally wrote the book on this do next?
He escalates. He takes his complaint outside the department.
Going over their heads.
Yes. On his own initiative, he submits a written, signed complaint disclosing this suspected discriminatory and retaliatory misuse of authority to the Miami-Dade County Commission on Ethics and Public Trust, the COE.
Okay, so an independent body.
Right. This is an agency that explicitly possesses the authority to investigate county law violations. He is attempting to force external accountability.
But what does the COE do? They dismiss the complaint. And their reason is the most crucial part of this whole saga.
What was their reason?
They claim they have a lack of jurisdiction over personnel matters.
There is that phrase, personnel matters.
Just like he said earlier.
This is precisely what Gray warned about in Acts 7 and 8 of his book, The Super Personnel Department Blind Spot.
It's playing out in real time.
The COE looks at a complex complaint about constitutional violations, unequal application of privileges, and official threats, and the institution successfully categorizes it as a routine workplace grievance.
And by slapping the label personnel matter on it, the COE washes its hands of it.
Making the systemic abuse legally invisible at the administrative level.
It is wild to see the theory play out so literally in the real world. But it gets worse. Immediately after the COE dismisses the complaint, the director of the department, Nathan Kogan, steps in.
And what does he do?
He alters Gray's supervisory reporting structure. He effectively downgrades Gray's status and forces him to report directly to Christina Salinas-Cotter.
The very official that Gray had just reported to the Ethics Commission for misconduct and threats of discipline.
I have to bring in an analogy here. That is exactly like a student going to the principal to report their school bully for stealing their lunch money. And the principal saying, sorry, I don't get involved in student interpersonal matters. And then the principal's solution is assigning the bully to be your permanent one-on-one tutor for the rest of the academic year.
It is a devastating analogy, and I'll add to it. Not only is the bully your tutor, but the principal tells the bully they are in charge of grading all your final exams.
Oh, that makes it so much worse.
It highlights the punitive nature of the structural change. It's not a neutral management decision. It is a weaponized reassignment designed to facilitate failure.
And the resulting environment is exactly what you'd expect. The filing details a sustained pattern of retaliatory conduct that followed while Gray was under Salinas-Cotter's direct supervision.
What kind of conduct?
We are talking about the public undermining of his professional standing, the restriction of his duties, his exclusion from work-related functions and meetings, and the reassignment of his core responsibilities.
This is the operational definition of engineering failure.
Yeah.
They have placed him in an environment where success is structurally impossible.
They took away the tools he needed to do his job.
By restricting his duties and undermining him publicly, they ensure his performance metrics will inevitably suffer. And when they do, they will point to the paper reality and say, look, he's failing to meet his core responsibilities.
Completely ignoring that they were the ones who reassigned those responsibilities away from him in the first place.
Exactly.
It's infuriating.
Yeah.
And the institution clearly believes they have won at this point, right? They think they have successfully framed this entire ordeal as a series of routine personnel matters.
But this is where Gray's lawsuit flips the script.
Right.
This is where we see the constitutional shift deployed in federal court to hold the untouchable accountable.
Let's break down the legal battlefront. Where exactly is this case right now, based on the source document we have?
We are at the motion to dismiss stage. The defendants, the county, Colgan, Salinas-Cotter, have filed a Rule 12b-6 motion to dismiss.
Okay, for those who aren't lawyers, what does that actually mean? What is the defense trying to achieve here?
A Rule 12b-6 motion is basically the defendants telling the federal judge, even if everything the plaintiff says in his complaint is 100% true, it still doesn't add up to a legal violation under the law.
So they want to end it early.
Right. They are saying you should throw the case out right now before we even get to discovery. It's a way to shut the door before the lights get turned on. They don't want to have to hand over emails or sit for depositions.
Naturally.
And if you read their strategy, it is entirely based on what Gray's brief calls attempting to deconstitutionalize the allegations.
Deconstitutionalize. Explain how they do that.
The defense wants the judge to view this entire situation through that traditional limited lens of employment law we talked about earlier.
The Title VII lens.
Exactly.
Yeah.
They want to reframe the denial of customary privileges as merely discretionary preferences of management. They want to reframe the systemic patterns of retaliation as just isolated decisions.
Trying to break it all up so it doesn't look like a pattern.
Yes. And they want to frame the misuse of delegated authority as benign managerial action. They are desperately trying to drag this case back into the super personnel department blind spot so the judge will defer to their managerial authority and dismiss the case.
But Gray isn't playing their game. His legal counterattack does not rely on Title VII. He is not fighting them on traditional employment law grounds. He is using 42 U.S.C. Section 1983.
Section 1983 is an incredibly powerful federal statute. It was originally passed in 1871, right after the Civil War.
Oh, wow.
Yeah, it was specifically designed to allow individuals to sue state and local government officials for civil rights violations. It is the primary vehicle for bringing constitutional claims into federal court when a government actor abuses their power.
I want to break down exactly how he uses Section 1983 to claim violations of the First and 14th Amendments, because the legal precision here is incredible.
Let's do it.
In Count I, he alleges unlawful employment practices based on equal protection and procedural due process. Let's start with equal protection. How does he prove that without a smoking gun?
For equal protection, he relies on a precedent called Village of Arlington Heights. He argues that discriminatory intent can be inferred from differential treatment and a departure from established practices.
So he doesn't need them saying something racist on tape?
No, he's telling the court, I don't need a racial slur on tape. I just need to show that I was denied a privilege that was routinely afforded to similarly situated white male employees without any additional conditions.
I see.
That departure from the norm is the evidence of intentional race-based disparate treatment.
And what about procedural due process? Earlier I said I thought due process was just about getting a trial before you go to jail. How does it apply to an office privilege?
In constitutional law, if you have a long-standing customary benefit or privilege at a government job, it essentially becomes a property interest.
A property interest.
Gray cites Supreme Court cases like Perry v. Sinderman and Loudermill. He argues that he was deprived of this customary employment privilege, which arose from established governmental practice without notice or an opportunity to be heard.
So they basically stole his property without telling him.
That's the argument. He's saying, you can't just revoke my property interest on a whim without a fair, documented process.
Then we get to count two, the petition clause violation under the First Amendment. This is where he attacks Salinas Cotter's threats of discipline.
Yes. He argues that his initial email petition disclosed discrimination and an abuse of authority by a senior official.
And that's protected speech.
According to Supreme Court precedent like Lane v. Franks, reporting the misuse of governmental authority isn't just an office gripe. It is a matter of public concern. Therefore, it is fully protected First Amendment speech.
Wait, I need to clarify a term I see in the brief here. Color of state law. It says she acted under color of state law. Does that just mean she was on the clock when she threatened him?
It's deeper than that. Under color of state law means she was using the power, the badge, and the authority given to her by the government to commit the violation. When Salinas Cotter responded with threats, she wasn't just being a mean boss. She was a government official weaponizing state power to unlawfully interfere with a citizen's constitutional right to petition for redress.
That is heavy. And count three addresses the retaliatory reassignment by Director Kogan. Under cases like Rutan v. Republican Party of Illinois and Mount Healthy, altering a supervisory reporting structure to force someone to report to a person they just blew the whistle on is a materially adverse action.
And it lacks any legitimate non-retaliatory justification.
And count four ties it all together into a retaliatory hostile environment. It frames the restriction of duties, the exclusion from meetings, and the public undermining not as isolated personnel gripes, but as a structural campaign to chill his First Amendment rights.
Now, here is where Gray has to overcome a massive legal hurdle that protects government officials' qualified immunity.
Right.
The defendants invoked qualified immunity right out of the gate to try and get the case tossed.
Explain why qualified immunity exists and how Gray defeats it.
Qualified immunity is a doctrine designed to protect government officials from being sued for doing their jobs unless they violated clearly established statutory or constitutional rights that a reasonable person would have known about.
So it's like a shield.
Yes, and it's notoriously difficult to overcome. It often shields bad actors because courts will say, well, there isn't a prior case with these exact specific facts, so the right wasn't clearly established.
So how does Gray get around that shield?
He uses a brilliant procedural argument. He cites precedents like Harlow v. Fitzgerald and Crawford L. v. Britton. He argues that qualified immunity cannot be resolved at the pleading stage at this very early Rule 12b-6 stage when intent, motive, and context are the core of the claim.
Right. You can't possibly know what their intent was until you get to the discovery phase and actually subpoena their emails, look at their texts, and depose them under oath.
Exactly. Because Gray has pleaded specific chronological facts supporting discriminatory intent and retaliatory motive, the judge cannot simply take the defendant's word that their actions were benign.
The judge can't just trust them.
No, the court can't just assume they were acting in good faith. The case must proceed to discovery so the truth can be uncovered.
And he doesn't just stop at suing the individuals. He ties it all back to Miami-Dade County itself to hold the entire institution accountable.
Yes, this is the claim for municipal liability. In federal law, there is something called the Monell Doctrine.
The Monell Doctrine.
Under Monell, a municipality like a county or a city can't be held liable just because it happens to employ someone who breaks the law. You have to prove that the unconstitutional action was caused by an official policy, a custom, or the decisions of officials with final policy-making authority.
And Gray argues that Director Kogan and Assistant Director Salinas Cotter were authorized decision-makers. They weren't low-level rogue employees.
Exactly. Their actions were the official policy of the county in that moment.
This entire legal document is a masterclass in translation. Gray is taking the theoretical framework from his book, The Managed Failure, The Conditions of Participation, The Paper Reality, and using it to systematically dismantle the institution's defense in federal court.
He really is.
He is demanding that the court refuse to deconstitutionalize his experience. He is forcing the system to explain its invisible structures, its unwritten rules, and its shifting expectations in the harsh, unforgiving light of a federal courtroom.
It's breathtaking to see it laid out like this. He is literally holding the untouchable accountable with absolute precision.
We've covered so much ground today. Let's synthesize this journey. We started with the realization that the old, visible signs of discrimination have been taken down, but the power structure simply relocated.
Right. It just moved indoors.
The Jim Crow and civil rights law exposes how discrimination evolved into invisible managed failure, a system that grants you entry at the front door, but engineers your failure inside through discretionary conditions of participation.
We saw how those conditions create a toxic feedback loop during the preparatory phase, culminating in a paper reality designed entirely for institutional compliance, not human fairness.
And we discussed how traditional employment law has a massive blind spot, constantly deferring to institutions because judges don't want to be super personnel departments.
But then we found the pathway forward, the constitutional shift.
Right.
Using the First and 14th Amendments to regulate how power is actually exercised in the environment. We learned the vital importance of lawful self-defense, replacing our natural emotional reactions with disciplined documentation and targeted questions.
Who made this decision? When did it change? Where is it written?
Exactly. And finally, we saw David Gray literally take his own advice in a high-stakes federal lawsuit against Miami-Dade County, surviving the procedural traps, demanding discovery, and forcing accountability.
The landscape has fundamentally changed. We have entered the accountability era. The system of structural, unwritten power has been revealed by Gray's work.
And as the framework states, now that it has been revealed, it cannot be unseen.
No, it can't.
If you are navigating any modern institution today, whether you're in government, corporate America, or academia, understanding these mechanics is not optional. It is essential. The knowledge must be applied.
And that brings us to our final thought. I want to leave you, the listener, with a question to ponder long after this deep dive ends.
It's a very important question.
Think about your own professional life right now. Look at the dynamics in your workplace. Are you currently navigating a preparatory phase without even realizing it?
Look closely at the feedback you're getting.
Yes, the scrutiny you're under, the privileges that are granted or denied. Are you participating in a genuinely fair evaluation? Or are you, through your own emotional reactions and lack of documentation, unwittingly helping your employer draft your own paper reality?
It all comes down to whether you are prepared to see the system that surrounds you and whether you are willing to record the soundless before it records you.
Remember that image we started with? The grand marble columns of equal justice and that rusted sign swinging in the shadows. The signs aren't hanging on the outside of the building anymore.
They've been moved inside.
They're woven into the very fabric of the procedures, the HR meetings, and the paperwork. Your job is to see them. Thank you so much for joining us on this deep dive. Stay curious, stay precise, and we'll see you next time.